Good morning, distinguished conferees. You are welcome to day 4 of the annual conference of the Rule of Law Development Foundation, dedicated to criminal law review. Yesterday, we had a session dedicated strictly to evidence, the law of evidence, particularly electronic evidence, and we had a lead presenter in the form of Honorable Justice Adileye, who took us through all the latest updates, both legislative and judicial, on electronic evidence. And we then went into a substantive session where we heard from Adedayo Adedeji on some of the core updates, and we had interactions with very eminent members of the bar in the form of Paul Erukuro SAN, Oyibi Ofyong SAN, and I know today will be no different. Day 4, we are moving into the realm of financial misappropriation and financial crimes, and the methods in which we use to safeguard the commission of such crimes and restrictive measures which the government takes, and in making sure that assets that are the proceeds of crime are not taken away from this beyond the state's grasp. Meanwhile, we're looking at also the right of the citizen to own property that he has rightfully earned. We have what you have, what the Marxists call a dialogue between those two competing rights: the right to own property and the right for the state to seize property that has been proceed of crime. And to give light on this very interesting topic, we have a chairman in the form of Mr. J.B. Daudu, Senior Advocate of Nigeria. Mr. Daudu, are you with us? He will be coordinating the proceedings, and the lead presenter on this topic of economic crimes and forfeiture of proceeds of crime is DC Ewolum, Senior Advocate of Nigeria. Let's give him a round of applause. And we'll have a panel discussion from Chief Mike Ozekome, Senior Advocate of Nigeria. He's on his way. I'm sure he will join the panel shortly. We have Neda Imasu Esquire, Senior Legislative Aide to Senator Matthew Orohide. I don't know if he's around. Then we have Chief Godwin Oblaisen, who will join us also as well. I have that indication that he will join us. But with us here in the Secretariat, we have an eminent senior legal practitioner versed in this area of law, Wahab Shitu Esquire. Let us give him a sounding round of applause. Senior, you're welcome. And that is our panel. And without much ado, Mr. Chairman, I hand over the proceedings back to you. Thank you.
Thank you very much, moderator. I welcome you all to the 4 of the Rule of Law Development Foundation's annual criminal review conference. This is not an occasion for long speeches. Paul has already explained the gamut of today's session, which is all about whether the forfeiture and other allied measures taken to restore what is regarded as stolen loot or looted property of the people conform with the law. It is going to be a very stimulating and scintillating session, and we have gathered the best on the field to do justice to the discussion. Now, it's a very sensitive area, and I'm very, very cautious at this point not to let my own viewpoints, my opinions, filter into what the already gamut of hard work that the learned presenters and discussants will throw light on. You would find that very erudite materials which were presented in the conference brochure, which we in due course will turn into a book of sorts when we get the remaining papers. Like I said, without taking too much time, I'll just set the ground rules. Mr. Welling, because we're starting late, if you see there, let the camera swing to him. Let me be sure that he is the person. Oh yes, not he's not Jibril of Sudan. All right, you're welcome this year, Welling. And I understand your co-panelists, a few of them are on their way. Martin, Chief Gordon Obla. So we start with
Mr. Chair. Mr. Chair, I'm happy to announce that Michael Zekome, SAN, has joined us. Let's give him a round of applause. Michael Zekome has joined us.
Yes, very well. Chief Mike, you're welcome. Now,
he signs and he prays. Where is he? Where is he?
Can you see me?
Oh, you are here spiritually.
No, I'm physically, virtually. I'm here.
Okay.
Now, because time is fast spent, I expect you are experts in presentation. So, this year will take 20 minutes, talk to his paper, emphasize the areas he wants to emphasize, and other discussants will start with 15 minutes. I have noted the rich work you have done, but please kindly emphasize just the areas that others have not spoken of. It's really, in reality, not. So I thank you very much. I would call upon Mr. Disen Welling to make his presentation shortly. Thank you very much.
Thank you. Good morning, Mr. Chairman, the Learned Senior Advocate of Nigeria here present, the panelists to discuss this topic, learned colleagues, members of the press. Good morning and welcome. The topic for discussion this morning is judicial updates and legislative developments, economic crimes, and forfeiture of proceeds of crime. The paper deals essentially with the latest developments in the judicial decisions as well as the bills recently passed into law or are yet to be passed into law, as well as the ones that are in the legislative process of enactment, as the impact on economic crimes and the forfeiture of proceeds of crime. Put differently, the paper is all about what is the latest judicial and legislative position on economic crimes and forfeiture of proceeds of crime. Now, we will look at the innovations on the legislative process on this topic, and thereafter we also look at the latest judicial decisions, particularly the apex courts, that impacts forfeiture proceedings. The first, of course, I've listed on page 2 the laws that guide economic crimes in Nigeria. I went further to state the authorities or commissions that have the authority to prosecute, investigate, and deter crimes, up to page 3. I took a closer look at the Banks and Other Financial Institutions Act, BOFIA, of 2020. And I stated that the Senate passed the bill to amend BOFIA. The bill was intended to update the laws governing banks, financial institutions, and financial service companies, enhance efficiency in the process of obtaining and granting banking licenses, and state in more accurate terms the regulatory functions of the Central Bank of Nigeria in the financial service industry. The bill also has as its objective regulation of the activities of financial technology companies, fintech, and increases the penalties for regulatory breaches in the financial sectors. Furthermore, the bill intends to strengthen the legal framework for the regulation of banks to prevent distress. Key provisions of the bill are as follows, and I listed the sections that empowers the central bank in the regulation of the activities of banks and financial institutions. I also talked about the Companies and Allied Matters Act 2020 and the new amendments generally to make it easier and cheaper for small and medium-sized enterprises and remove most of the regulatory hurdles so as to create ease of doing business in Nigeria environment and to stimulate growth. The third one is the Corrupt Practices and Other Related Offenses Act Amendment Bill in April. And I stated the objective of that amendment, the principle of which was to enhance speedy prosecution of cases, and Section 72 of the proposed bill removed hearing of stay of proceedings in criminal trial, which caused delay. Essentially, is also in line with Administration of Criminal Justice Act 2015. We then go on to the judicial updates, and I picked two superior cases, superior court judgments. The first is Dame Patience Ibifaka Jonathan against Federal Republic of Nigeria, 2019, 10 Nigerian Weekly Law Reports, part 1681. The second one is Joy Obiageli Oti against Economic and Financial Crimes Commission and one other, 2020, 14 Nigerian Weekly Law Reports, part 1743 at page 48. Now, in the case of Dame Patience Ibifaka Jonathan against Federal Republic of Nigeria, cited Supra, the Supreme Court held as follows. One, that the EFCC can, by order of court ex parte, take into custody and retain any property suspected to be proceeds of some unlawful activity under the Money Laundering Act. The High Court shall be reasonably satisfied upon the facts placed before it in the affidavit in support of the application before making the order. We shall look in greater detail later what constitutes being reasonably satisfied upon the acts. We will look at that later. Two, that's the second part of the decision. Any interim order of forfeiture made under Section 17 of the Advanced Fee Fraud and other Related Offenses Act is consistent with Section 36(1), that is, fair hearing, and 2 of the 1999 Constitution. It is therefore not an order made in violation of Section 44 of the 1999 Constitution. Section 36(5) of the 1999 Constitution provides that every person who is charged with a criminal offense shall be presumed innocent until he is presumably guilty. However, the proviso to this section provides that nothing in this said Section 36 of the Constitution shall invalidate any law by reason only that the law imposes upon such person the burden of proving particular facts. See the lead judgment of ACAS JSC as it then was at pages 564 to 565, paragraph G to A and paragraph F, and the supporting judgment of AJMB ECO JSC at pages 581, paragraphs A to B. Now, let us take a closer look at some of the details of that judgment. I started with the case of, first of all, we now go to the judgment in them, Patience Jonathan. And if we go specifically to pages 456 to 458 of the judgment cited in 2019, 10 Nigerian Weekly Law Report, part 1681. I will take a look at the comments of the justices of the Supreme Court in that case. The first is that of Muhammad JSC. He said, a communal reading of the three clear and unambiguous constitutional provisions entitles the appellant, that is Mrs. Jonathan, by virtue of section 42, to own the sums in the two accounts. The right is not absolute. And I want us to pay attention to these reasonings of the judges, because it will help us when we are now looking at whether that reasoning can be looked at all over again. He said the right is not absolute. Given section 17 of the Advanced Fee Fraud and Other Related Offences Act, the sums in the two accounts in Skybank PLC and EcoBank Nigeria Limited may be forfeited to the federal government of Nigeria if, as necessitated under sections 361 and 44(1) of the 1999 Constitution, she had been accorded fair hearing before the forfeiture. Section 42B, Section 42(2)B and K of the 1999 Constitution further subsumes the provisions of Section 17 of the Advanced Fee Fraud and Other Related Offences Act and gives the toga of legality. I am in complete agreement with the learned respondent counsel that the latter section is in complete harmony with the constitutional provisions. Now, Ejimbieko stated, it is clear from the provisions from paragraphs 4 to 6 of the counter affidavit that the EFCC suspects, underline that word suspects, that the funds sought to be forfeited are proceeds of crime of some unlawful activities, and the interim forfeiture orders were necessary for the temporary attachment of those funds in the course of their investigation. The question is whether the EFCC has sufficient interest as an investigating and prosecutorial body in the interim orders it sought and got. The situation, then he made reference to judgment of Lord Denning. Now, this represents the main reasoning of the Supreme Court in this judgment. What they are saying is to get interim order of forfeiture. One, the owner of the property will not be put on notice. The prosecutorial bodies or investigating bodies, they go to court, file application for interim forfeiture, and the only basis is, do they have interests in the property they want to protect? And this interest is simply if they suspect that that property is a property or asset, please, not just property or asset. That property or asset is a proceed of some unlawful activity. That is their reasoning. And I went on to refer to the judgment of Justice Ikie in Oti against the EFCC. He said, proceedings under Section 17 of the Advanced Fee Fraud Act cannot be said to violate the appellant's fundamental rights, in that the legislature is entitled under Section 44B of the Constitution of the Federal Republic of Nigeria, 1999, to enact laws derogating from Section 44 thereof on the ownership of the property for the imposition of penalties of forfeiture for breach of any law, whether any civil process or after conviction for an offense. He went on in paragraph H. The Supreme Court further held in Dame Patience Ibifaka Jonathan against Federal Republic of Nigeria that forfeiture is constitutionally permissible, even in the case of a joint owner of property, because the property subject to forfeiture was the evil sought to be remedied. Therefore, historically, consideration was not given to the innocence of the owner of the property. In other words, the innocence of the owner of the assets or property is separable from the property and assets sought to be attached, whether you are guilty or not. The important thing is that not necessarily the investigative bodies or the prosecutorial bodies suspect that that property is proceed of some unlawful activity. That is the only interest they say should suffice for the grant of the application. It is proper, therefore, that we examine the reasoning of the appellate courts in the above two cases cited. Now, Section 17 of the Advance Fee Fraud Act, as well as Section 29 of the EFCC Establishment Act 2011, both make provisions for the EFCC and indeed other agencies investigating economic crimes to apply to courts in an ex parte motion and satisfy the courts that there is a prima facie evidence that the property concerned is liable to forfeiture. We now come back to the reasonable facts I referred to earlier on in the judgment of Justice Sakas. We take it as prima facie evidence. The contention over the years, and that is what is still operable today, is satisfy the court that there is a prima facie evidence that the property concerned is liable to forfeiture. Our position, or rather my humble view, is that prima facie evidence requires objective tests. In its ordinary meaning, prima facie evidence simply means credible evidence. This was stated by the Supreme Court in the case of Agbi against Ogbe, 2006, MJSC, page 1 at page 23, where it held as follows: that prima facie evidence simply means evidence worthy of belief. And for evidence to be worthy of belief and credible, it must not only proceed from a credible source, it must be credible in itself, in the sense that it should be natural, reasonable, and probable in view of the entire circumstance. Now, if we apply the definition given by the Supreme Court in Agbi and Ogbe, credible source in that definition will refer to the investigating authorities or prosecuting agencies, and that is EFCC, ICPC, and so on. That should be taken as being credible source. The next one is whether the information they are giving to the courts as a reason for applying for the forfeiture of this interim forfeiture of these properties, is it natural? Is it reasonable? Is it probable? And again, I'm starting from Esai Dangaba against Federal Republic of Nigeria. I gave the citation. AR against Security Solutions Limited against EFCC, the citation is there. Down to Patience John Ibifaka Jonathan against Federal Republic of Nigeria, the citation is there. And Joy Obegeli Uti against EFCC and one other, the citation is there. That it is sufficient that the EFCC has arrested a person, or that the person is under investigation for the commission to attach his or her properties or assets and apply to the courts for a forfeiture order. And so the issue is settled in law because the Supreme Court is final. However, our contention and my humble view is that reading Section 29B of the EFCC Act together with Section 17 of the Advance Fee Fraud Act, Section 44 of the 1999 Constitution, the credible evidence, going by the interpretation of what credible evidence means in the case of Agbi and Ogbe, which is from the same Supreme Court, the credible evidence must mean evidence which in itself must be credible in the sense that it must be natural, reasonable, and probable. And therefore you see his property. Is that natural, reasonable, and probable? It's only your own opinion. You are doing this based on your own opinion. Again, the mere suspicion that an asset or property was acquired unlawfully without more will not be sufficient. The agency concerned should furnish the court with evidence of how they arrived at the fact that the assets or properties were acquired through unlawful means. And such evidence, in my humble view, should include the following. 1. Searches conducted at land registries, statements of the people interviewed, documents evidencing the transactions itself, the source of income with which the property was purchased directly linked to the acquisition of the property. When you present this, it begins to show that, look, not that you are certain question is a proceeds of unlawful activity, but to say I suspect, and of course, see, I'm going to go further into it, but we have to bear in mind, laws are meant to address the peculiar situations in a particular circumstance. We're not looking at, later we'll talk about where Justice Sakas in his judgment derived the main reasons from outside Nigeria. But in Nigeria, we are looking at the way the investigating authorities operate. Are they thorough? Are they sincere? Are they unbiased? Are they too hasty to arrive at a predetermined end? In the light of all these, it will be necessary for us to situate the reasoning within our own circumstance. That is why I said nobody is saying the security agencies are very efficient. I concede that to them. But then to go to court and take hold of somebody's property and say that is enough, and we rush back and tell the court, I am suspecting AB. I am suspecting AB. And the same constitution says suspicion, no matter how, it can never amount to proof. Now, I continued. The Honorable Justice Sakas, as he then was, has relied on the case of Butler against United Kingdom, December number 41661/98, which interpreted, that's the Britain now, which interpreted Proceeds of Crimes Act, POCA 2002. He further relied on U.S. cases of United States against Ossery 95-3.345, 518 U.S. 267, as well as the case of Bennis against Michigan 94-8729 and 517 U.S. 1163, to the effect that interim forfeiture proceedings are separable from the innocence or otherwise of the accused person. It is submitted that while the interpretation given to the Proceeds of Crime Act, POCA 2002, is in order, the circumstances in the UK and Nigeria are different. And it is settled that foreign decisions are only of persuasive value in Nigeria. The circumstance in Nigeria is that agencies on arrest without more and without seize or take forceful possession of suspect's property, rush to courts, obtain interim forfeiture order ex parte because of the position of the appellate courts have taken. They neither investigate the real ownership of the said property nor the relationship to the crime being investigated or alleged. What we mean here is Mr. A is suspected to have laundered money as a result of being a former governor. We are given an example. His tenure may have been from 2010 to 2015. Before he became a governor, he may have acquired 1, 2, 3 properties. He may have had 1 or 2 other assets. He is being suspected to have indulged in unlawful activities with state funds within the period of his tenure. But in the process of investigation, anything belonging to him, including the house where he's living with his family, which he may have built before he became a governor, all of them will be seized. And it's very, very easy. Once they get interim order, they go there, EFCC. Sorry. Okay, ICPC. Let me not be calling EFCC. I hope there's no EFCC here. But they go on and attach, place that order, and everybody vacates. Still going further, they neither investigate the real ownership of the said property nor the relationship to the crime being investigated or alleged. Usually, the sole reason is to save the assets from being dissipated. In their efforts to keep hold of the property, they even go further to appoint estate managers of the said properties who now put these properties to commercial use, collect the rent or interest, and keep same. Furthermore, instances abound where properties are taken possession of and left to waste by the agencies that have confiscated them. Well, they have been forfeited to by order of court. Relying on the decisions of our superior courts, the security agencies refuse to ascertain the status of the assets or the properties they attach or obtain interim forfeiture. They simply seize these assets and properties arbitrarily and rush to court to obtain interim order of forfeiture. The owner of the assets or properties, who may be a suspect, is now made to file a case to challenge the interim order at his expense of time and resources. In the event he succeeds, the property has lost value due to poor handling and lack of maintenance. Instances of this abound all over the country. Once a property is marked EFCC keep off by the Economic and Financial Crimes Commission and then secured by them, the property is left in that state without property managers to manage or cater for them. Even in the case where they are managed by estate agents and the owner succeeds in proving his ownership, incomes received during the interim order from the property, example rents, are never handed back to the owner. These are some of the concerns that the courts should have mitigated at the stage of the grant of interim order of forfeiture. The concerns here raised demand that the courts take a second look and review the reasoning in the grant of interim forfeiture. I then went on at which courts should be deciding these cases of interim forfeiture. And I said, we also need to highlight the issue of the federal high courts and the state courts as to which has jurisdiction to try the offenses of economic crime. Some legislations like Money Laundering Prohibition Act 2012, see Section 20 thereof, have stated that the federal high court shall have exclusive jurisdiction to try such cases. However, Federal Republic of Nigeria against Okenwosu and 3 others, 2016-17 Nigerian Weekly Law Report, Part 1541, page 226. Ontario Oil and Gas Limited against Federal Republic of Nigeria, 2018-13 Nigerian Weekly Law Report, Part 1636, page 7. The Supreme Court has held that the cases the Federal High Court should have exclusive jurisdiction in terms of forfeiture proceedings should be those that relate or touch to those items listed in Section 251, paragraph 1, A, B, C, D, and F. For the others, they share equal jurisdiction by virtue of Section 251, subsection 3 of the 1999 Constitution. I hope I have not exceeded Mr. Chairman, I hope I have not exceeded my time. But I think my role is to stimulate extensive discussion on this topic. I thank you once more, and I thank you for your patience.
Well, thank you very much, Please, can we give him another round of resounding applause for newspaper in this touchy subject? I hope I'm being heard. I can be heard.
We are hearing you clearly.
Okay, very well. Now, I will not undertake a review of the bullet points of what you have said. What you have said is self-explanatory. I'm really very cautious of not allowing my views to seep into this matter until I've at least had all the presenters in this. Then maybe I can intervene if necessary. So I go to the next presenter. That is my very good friend, Chief Mike Abu Zokeme, with over 100 chieftaincy titles, a plethora of degrees. Above all, these are not really material, only that he is known for his towering intellect and his human rights credentials. He has fought in the trenches for the liberation of Nigerians, and nobody can underestimate his resolve in standing for the truth. So it is my privilege, singular privilege, to invite Chief Michael Zokome, SAN, to make his presentation. His presentation you see at page 220 of the conference book. So, Chief Mike, have the floor.
Thank you, sir. Mr. J.B. Daudu, great man, great Nigerian, very deep in law, very lucid. I always call him my pet word. He is the Chief Rotimi Williams of Nigerian law, both in size and in brain. And that you are organizing this series is great development to our law. My only humble advice straight away would be that when we finish, you should be able to compile the entire proceedings into a book. Particularly, there must be chapters on recommendations. Very important. Let me thank my learned brother, DC Enwelum, for his very, very deep and well-researched paper. I read it. It opened up new vistas to me, and I was quite guided in some of the areas of the law. As a scholar myself, I always like to read and listen to others. That is why I write 5 columns in 5 Nigerian newspapers every week. I don't think any Nigerian, living or dead, with all respect, has ever achieved that. Let me also say, with all humility, that on the 26th of April, 2015, ever before the present Mr. President, Muhammadu Buhari, was sworn in as President of Nigeria, I wrote a series of articles. One of them, it was published yesterday. I republished it yesterday in my back page column of Wednesday Sun newspaper, where I made 2 telling statements. That corruption in Nigeria has become so gargantuan that it has actually become the 37th state of Nigeria and the richest and most and more powerful. And that we must kill corruption before corruption kills us. I then went on to outline for Mr. President what I thought he should do to make the anti-corruption war successful. I gave him a program of action, like Nostradamus, the man who saw tomorrow. I knew that the anti-corruption war was going to head for failure if he did not follow up those suggestions. I went after that in 2017 in June at a roundtable conference with Kako in Lagos. I gave 24 suggestions. I called it the 24 do's and don'ts of fighting the anti-corruption war, or the A to Z of the anti-corruption war. Again, of course, when you are not with the government and you are sounding a different note, which is a note that should be taken as a resonating voice in an oasis, they will term you an enemy. When you defend people accused of corruption, they will term you either a corrupt lawyer or an enabler of corruption. They forget that the same government is using the best lawyers, senior advocates that they can have to prosecute those same people. The ex-acting chairman of EFCC, Mr. Magu, we met at 3 seminars. Thank him One of them he actually invited me to, and I confronted him face to face. I said, you will fail in this anti-corruption war. These people clapping for you, they are Nigerians. That is how they are. It's Hosanna today, crucify him tomorrow. Build strong institutions and not strong men. I said, are you aware that your EFCC itself is being accused of corruption? That it is now worse than the Nigeria police force? That money is being extorted from detainees, from suspects. He was kind enough to listen to me, I must confess. Some people did not even want me to speak. He said, no, I invited this man here because I want candid opinion. But the question is, after hearing all these opinions, did you work with them? The fate that has finally befallen him now, I saw it, and I told him in June 2017. I again repeated it in December 2017 at the Federal High Court premises, Abuja here, when Justice Auta was launching his book after he had bowed out. I confronted him. All you need to do is just to say, Ozekome, Magu, EFCC, confrontation. It's all over on the internet. So the problem we're having in the country is not that we don't have enough laws. My brother has given virtually all the laws we have on recovery of properties and all that. They are there. I've even added some to your own list, even though we never saw our papers when we were preparing. I saw your own later here. I dwelt on some that you dwelt on. I added 2 or 3 more. Now, the question is, have we been fighting corruption holistically? And that is why I want to talk almost extempore, except when I now go to some recommendations, because my paper is already here. And I'm always very, cautious about doing the talking, but without walking the talk. We can present all the papers in the world. We can say everything we want to say. But do we have the will, particularly the political will, to do that which is good in the estimation of God and the people? Why would you fight corruption in government cycles with your cronies by using Sasarobia perfume? You hug corruption. You perfume your body with it. But when it comes to critics, to opposition, to different voices, you suddenly start fighting corruption with herbicides, pesticides, and insecticides. Fighting corruption cannot be separated from respecting our fundamental rights. Do you have to show that you are fighting corruption by arresting people, put manacles on their legs and shackles on their hands, and then you drag the people on the ground? What of their respect for human dignity? What of Section 7 of the Administration of Criminal Justice Act, to treat people with humaneness? What of their right to liberty in accordance with Section 35, subsection 5 of the Constitution, that when you detain a person, you must send him to court within 24 hours, where there is a court within 20 miles radius? Do you do that? Do you have to, according to the government, name and shame the people? As a policy, you stigmatize people, you paint them, you color them with the paintbrush of shame, of odium, of obloquy, of derision. You say, oh yes, so that future generations will know that we said this man was corrupt. How many of those people have ever been convicted in the last 6 years? I can count them with the fingers of my first hand. I will not raise up this. So why carry out media trial of suspects? I noticed that when Magu was now detained, his lawyers were shouting, oh, they are giving him media trial. They are giving him. I said, oh, really? Oh, so there's something wrong with media trial? I still came out and pleaded with Nigerians. I said, Nigerians, I beg all of you, give him his right to fair hearing. Don't try him in the public domain. Allow him to have his day in court. These are some of the things some of us have been talking about. And when I say it, they say, oh, why is he defending Patient Jonathan? Or why did he defend Ayo Fayoshe? Why is he defending Dokpesi? Why is he defending Farouk Lawan? The same people forget that I defended Adeyanju, a human rights activist, that I defended Monday Ubani, that I defended the young man from Abia State, all of whom are critics of government, but whose faces are therefore detestable. But once you defend a person whose rights have been breached, you are either an enabler of corruption, or according to them, corruption is fighting back. Question: is our system of justice no longer accusatorial, which is Anglo-Saxon based, that the innocence of a person is presumed, which has been encapsulated in section 36 of the 1999 Constitution? Is our system of justice the French model, which is inquisitorial, where your guilt is presumed? The answer is no. If that is the case, then I will agree with Enwuru, and that has always been my view, that at no point in time are you going to shift the burden of proof in criminal cases, and you now tell an accused person or a defendant to come and show and give evidence that he is not guilty. If you want to change the law, I'm okay with that. But for as long as section 36 of the Constitution is there, for as that case and the immortal words of Lord Denning in Rondell against Worsley are there, for as long as the cab rank rule operates, you cannot begin to tell an accused person to come and prove his innocence. I give an example. I want to agree perfectly with my brother that these judgments by the Supreme Court, where more or less they are overruling Akingbola versus EFCC, overruling cases like Waigwe, FRM versus Waigwe, and Felimon and EFCC, the Supreme Court may have to go back and look at them. Those were the right decisions. That you can never, ever, ever tell a defendant to come and prove his innocence. It is for you to prove his guilt. And the Evidence Act says it must be proved beyond reasonable doubt. So, for example, you catch a senator driving a very beautiful car, a Ferrari. You say, oh, I suspect, according to the section 70 of the Money Laundering Act, I suspect that you have bought this Ferrari with proceeds of unlawful activity. I therefore attach the property. They seize the property. You are now expected to come and prove that you are the owner. Supposing the papers of your car had been destroyed in a fire accident. Supposing you no longer have the papers for one reason or the other, it means that that property is finally forfeited to the federal government of Nigeria. because you cannot show proof of ownership that you own it. That has subverted our criminal justice system in a very dangerous manner. Those cases you were citing, Patient Dame Jonathan, Lawari Furnitures, I handled them with Adedikpe, Senior Advocate of Nigeria. And the Supreme Court, in my humble opinion, were wrong in the appraisal of the issues. But like they said, I think in Adegoke's case, the Supreme Court is final in the sense of all finality. It is final not because it is infallible. It is infallible because it is final. Although you cannot go to the Supreme Court and say, review this judgment, which they have said again and again we cannot do, and they also said it again in my case, Governor Matawale of Zamfara State against APC. They can, however, in future, in other cases, say, wait a moment, let us look at these laws again. Were our decisions right or not? So in fighting corruption, you cannot help the government to do its work. You cannot help prosecuting agencies to do their work. ICPC, EFCC. You all know how the system operates. And that is where, again, I agree with DC Enwelum, that all those decisions of foreign courts, you are citing them out of context because you are not looking at our peculiarities, at our bad belly politics, at our PhD, pull him down syndrome. They don't look at that. For example, a prosecuting agency abroad, before they arrest you, they have done all their investigation. The day they invite you, be very sure that latest tomorrow they are charging you to court. But from my own experience, and I've handled tons.
2 minutes.
Yes, sir. Yes, sir. I've handled tons and tons of these cases. My own experience shows that they will first arrest you, detain you, seize your phone, and begin to scroll through to see your information. Then they throw a net in the wide sea to see whether any fish will swim in. Then they begin to ask you questions, some of them asinine and inane questions. Why would I help you? I always tell people, it's just that Nigerians are too cowardly. If they detain you, if you look at the cautionary first paragraph, he said, you are not obliged to say anything, but anything you say may be used in evidence against you. Go to them and sit there and say, yes, you have invited me, I'm here. They say, Phil, you tell your story, I was born on so-so date. Okay, what was so-so property? You are looking, mom is the word. How did you acquire? Mom is the word. Just stay there. Let them detain you for as long as you have done something, let them charge you to court. Mr. Chairman, sir, and the convener, some very quick recommendations that I have here, sir, which I think will be helpful to us here. We should never allow the EFCC, for example, to be the investigator, the prosecutor, and then the keeper of the Commonwealth. It has now been shown that looted items but recovered can also again be relooted. And relooting is a worse form of corruption. Prebendalism, cronyism, nepotism, favoritism are worse forms of corruption than the giving and taking of money. The giving and taking of money is corruption, quite all right. But it is a lesser form of corruption when you compare it with nepotism in appointments, prebendalism, favoritism, sectionalism in giving contracts, in enriching some people to the disadvantage of some others, contrary to Chapter 2 of the Constitution. So, in appointments where the entire security architecture in Nigeria resides in one section of the country, and then you are talking about corruption. What corruption can be worse than that? that you forget that I'm from Ijukwe, near Agenebode, in Edo State, that my children should be considered on their merit, that you can only see from your area. I want to be. So some of the recommendations, sir, is that the investigating offenses, security agencies should accord the people their fundamental rights. They are not mutually exclusive. Stop using government might. Build strong institutions, not strong men. The obnoxious policy of name and shame is outrageous and should be discarded because the people may be found never to have done anything wrong. Scrap the Presidential Advisory Committee Against Corruption, PACAC. In fact, it is one of those cogs in the wheel of progress. That panel actually defended Kemi Adeosun. I said, oh, what does it mean to forge a NYSC certificate? It's not big deal, Buhari. Don't remove her. They are jealous of you because she's your best minister. The woman saw between the lines and resigned quietly. God bless her. They say, oh, one of them, and I challenged him at one of the seminars I was invited to. I don't want to mention his name. You a professor, you are a member of PACAC. We saved you when you were arrested and manacled and shackled with General Dia and others from death. You say people should not even be tried for corruption. They should even just shoot them at stakes without trial to show that we are fighting corruption. Create a separate independent prosecuting agency, Mr. Chairman and Mr. Convener. Create a separate process of crimes agency. I call it POCA. Process of crimes agency, where you can domicile all recovered loot and money, so that you do not allow the keeper to again be the recoverer and the seller. Power corrupts, and absolute power corrupts absolutely, and we have seen it. There's the need for interagency cooperation, ICPC, EFCC, DIA, NIA, and the rest. Let them not be jealous of each other, with each trying to outdo the other and impress Mr. President. EFCC should never again be headed by the police. Never. Don't let EFCC be headed by the police. Allow people who have been trained within the EFCC apparatus, who went to their law school, to their school at Karo, who have climbed the ladders. Allow one of them to be Director General. Then get a chairman who is a retired justice of the Court of Appeal or the Supreme Court and a man of integrity, so that they can together fight this anti-corruption war. Halt the lopsidedness in anti-corruption war. Let it go round. Prosecute your own people that you have found corrupt. And I say, sir, I said, EFCC must be transparent, including ICPC, in their dealings with corrupt matters. They must obey court orders. They must stop humiliating judges, arresting them in the night. How many judges today can give judgments according to their conscience when you barge into judges' houses between 12 and 4 a.m. and they are afraid? And do you know what? They say many of them do have meetings, secret meetings, with judges that have been nominated as anti-corruption cases judges, behind the back of the defendant and their counsel. Where is the justice in that? There is God. EFCC and ICPC, I said they must stop forum shopping and abuse of court process. I've handled many cases. As soon as I win, they will take the same case and run to another judge in Federal High Court, Lagos. They will run to one in Kano. Then they have this post no debit something. They will just write a bank and say, close that account. The bank afraid, they will close. Do you know, sir, how many cases I've won against the EFCC? When we write to the bank and say, pay the money, the bank will write to us and exhibit a letter. I say, sir, this letter has been signed by EFCC chairman or so person. They say we should not pay you. So we got to a sorry state of nedai, of shame, of odium, where an EFCC letter is more potent and is obeyed more than an enrolled certified court order. Sir, we should never allow that to happen. And no international investor will come to your country once they find out their laws are not obeyed, particularly judgments are not obeyed. So stop the denigration of the judiciary and of judges. The EFCC, ICPC, they must not win every case. It's not compulsory. When you have seen a bad case, let go. Use Professor Wyden's principle. Let go and let God. It's not going to end. And I say NBA and LBDC should checkmate the prosecutors and defense counsel to bring them to book where they are siding with these EFCC people and humiliating the judiciary and judges. And I say, I'm almost done, sir. I'm grateful, sir. I said they must stop leakage, media trial and leakage of sensitive materials. EFCC is interviewing a client, my client. The client verbatim tomorrow will be published, the interview, in a particular newspaper and one particular online newspaper. Is that how to run it? Verbatim. Statements being made, and then they will now tell these detainees, well, if you cooperate with us, if you agree to forfeit this, you do this. So they are corrupting evidence. They are corrupting the system. They must also respect the Halal doctrine or separation of powers, as ably propounded in 1774 by Baron de Montesquieu, that great philosopher, between the executive, the judiciary, and the legislature. And they must stop castigating lawyers who are just doing their job to defend people accused of offenses. They should stop and wiretapping and eavesdropping on suspects and lawyers' conversations. Be sure that when you have a client, they have equipment to monitor you, and anything you discuss with your clients, they are monitoring you. It's not necessary. They should use the positive aspects of the Constitution and ACJA, not the negative aspects. Those positive aspects that recognize our human rights. They should stop this interim detention for 14 days. They run to a magistrate court, obtain an order of detention. When they have not finished, they run back again, extend it. You cannot do that. Finish your investigation before you call a person, before you arrest a person. Then I say, Fansa, that capacity building for the EFCC personnel should be brought in. They should abolish too many security guards for any EFCC chairman or director general, because it makes the people to fear them. Where the EFCC motto is, nobody is above the law, they themselves have been operating above the law. They should enthrone internal control mechanism to show that assets are not relooted after they are recovered. And of course, the EFCC Establishment Act of 2004 should be amended immediately to bring in some of these fresh innovations that I have talked about, particularly sections 2 and section 6 of the Constitution, of the EFCC Establishment Act 2004. So my learned brother, Enwelum DC, God bless you, Mr. Chairman, sir, and the convener, JB Daudu, great Nigerian legal practitioner, a patriot, a man who, though not with us in the trenches, has a strong voice, which is pro-masses. We thank you for this thing you have done. Continue to do it. If you want me to organize one for you next year, just tell me. I will help you. I will sponsor it, because you are doing a damn great job. And please, the process of this one should be put in a book authored by J.B. Daudu and Paul Daudu, Esquire. It's a great work you have done. God bless you all. I thank all of you.
Thank you very much, Mike Zekomi. Please let us give him another round of applause. Like I said, I really do not want to go through in summary what has been said. I leave you to digest it. However, one must note a number of things that he has said. While he was speaking, I went through his paper, and I just like to recommend, and that's why this material is interim for now, because he has given about 17 to 20 recommendations, all of which are substantial
And they are not here.
in nature.
They
They are not here.
They are not in this paper, no.
So I'll be appealing to you, to Chief Magistrate Committee, to update and upgrade your paper, and let us have the recommendations attached to it,
Okay.
so that we can now publish. You notice that some papers are not here,
Yes.
so
Good.
that we will now transcribe this, edit it properly, and then have it in the book form and distribute among the stakeholders.
So I can go
For
to
now,
I can go to town, sir, and write more. Because
yes.
I had so much to write, I was restraining myself. Can I write more, sir?
You
Okay,
can
okay.
put
Okay.
down.
Okay.
So that we now embed it as a chapter in the book that is going to succeed this conference. So thank you once again. I hope, ladies and gentlemen, you are taking notes. I want to have enough time for us to have a robust discussion. As you have noticed, I have not said a word on some of the things all the things that have been said by both. I do not know if the representative of the senator is there.
Mr. Chairman, sir, is here. I was about to draw your attention to that, sir.
Okay.
He came in while the paper was being discussed.
And so he's
And you represent? Yes. He's here, sir. The camera can, please, can the camera show us? He's here.
Thank you.
I would-
We will take your paper now. Regards to the distinguished Senator Matthew Roide. After that, I don't know if you've got enough light.
Yes, my lord. Yes, Mr. Chairman. He's here as well. We have Chris E. Agviti, Esquire, representing Godwin Obla. He has joined us as well.
All right.
So
Very
the
well.
panel is properly constituted, sir.
Yes, we are trying to save Rajwahab Shitu for last. I think it is only fair and proper to allow him speak last on this point. And I will not abridge him that much. But for those on the side of the defense and the legislature, please, you have the floor is open. Let us take Master now. Please try and stay within 15 minutes, because we are beginning to feel the constraint of time. So the floor is yours.
Okay, very well. Thank you very much, sir, and panelists and colleagues here present. I represent the distinguished Senator Matthew Roide, who is the Chairman Senate Committee on Public Accounts. And he sincerely regrets his inability to be here, and I'm sure that we are all very familiar with what is going in the National Assembly regarding the budgets and all that surrounds it. Besides, his committee continues to sit, and being the chairman, it's always very difficult for him to leave. I also would have had to be with him now, but I haven't checked through the schedule, and did that difficult of him leaving, he said I should please represent him. Having said that, I don't know about presentation of paper anyway, but having sat here and listened to my learned seniors here, I also have my own personal observation. Our legal system, as have been said so many times in other fora and also here, it's in itself a very corrupt system. I'm not saying that the judges are corrupt. There might be some corrupt ones amongst them, but that is not the root cause of it all. I think there's a systemic corruption that pervades the system in such a way that the common man or woman do not get justice. Listening, I took a note of what Ozekuben San said about forum shopping. And I've had the occasion to discuss it with some friends who practice here in Nigeria. I really have not practiced here. I practiced in New York. And when I came back, I couldn't understand certain things. Some of which is you have a case in a state high court in Benin, and another party will go to Port Harcourt and institute the same case, the same facts, nothing changes. And that judge in Port Harcourt will accept the case. That is so strange to me. Where I practice, like I said, when you file your papers, there's what they call attorney's affirmation. It must go with your papers. If it doesn't go with your papers, it's not accepted. And always clause 5 or 6 of that affirmation will state, and this is lawyer, the lawyers affirming now, that to the best of his knowledge, this case is not before any other court. If that affirmation is not filed, your case is not even listed. And so when you go to that affirmation and says your case is not before any other court, they accept it. If you say the case is before another court, that judge will tell you, look, I'm very busy here. Go back, take that case to where it is, and let them deal with that case there. The judge will never accept it. Never. And so this question of forum shopping, looking for justice, injustice I will call it, that they will call justice, is something that is so strange to me. And I'm saying, why is it a problem in Nigeria? Why can we not do the same thing? Is it, I don't know, what is the bottleneck? What is the reason why a case before a competent court, coordinate jurisdiction, would be before 2, 3 courts? I don't understand it. It's, first of all, waste of the taxpayers' money, waste of time, waste of the court's time, and it doesn't serve any interest of justice. It's strange to me. Another observation that I made is this EFCC thing. Working in the National Assembly, I remember very clearly when Magu came for confirmation. And if you sit there and watch what went on between EFCC and some other sister agencies, that came with a laundry of why he should not be confirmed. The Senate didn't confirm him, but the president left him there. And I'm asking myself, if the Senate does not confirm this man, why will you just tacitly leave him there to continue to do what they say he shouldn't be doing? So you look at the executive and look at what they are doing and how to do what they do, you just now know that they are, in my opinion, perpetrating this injustice. If Magu was not confirmed then, I'm sure part of the issues that we are saying now would have been addressed on his behalf. He's been removed now, unfortunately, or fortunately, but he should have been removed then. Finally, without taking much time, because like I said, I wasn't told we were going to present a paper. But finally, looking at the depth and the academy of this conference, and as I can see, it's been going on, I will advise that some law students, even if it's just 5, 10 of them, from even if this University of Abuja here should be invited. Because certain education you get from here, you will not get it in your classroom. And this is so invaluable even for a practicing lawyer, that in the courtroom, if this is all you have, I'm very sure you can prosecute your case successfully. All that said, I thank you, Mr. Chairman, panelists, for this opportunity. And I say kudos, God bless, and congratulations for this seminar. Thank you.
Thank you very much, Neda Emerson, Esper, Senior Legislative Aide to Senator Matthew Roy. Please, another round of applause for him. It was short, snappy, but very thoughtful. I now go to, I will note particularly your suggestion that we should allow law students, particularly those in the law school. That's a very noteworthy suggestion. I'm sure the rapporteurs are taking note. Let's just hope by the next time we're having this issue of strikes and COVID-19 exclusions will have been resolved. So thank you very much. May I go right away now to Mr. Agiti from Chief Obla, to go straight into his paper.
Mr. Coordinator, sir, of the Rule of Law Development Foundation, the chairman of this panel, learned Sikh here present, ladies and gentlemen, I came here standing wearing the shoes of Chief Godwin Obla SAN. He was going to come, having made enough preparation to come, but at the last moment, he became indisposed by reason of ill health. He has asked me to stand in for him. I will be making a presentation on our topic, judicial updates and legislative development, economic crimes and forfeiture of proceeds of crime. The advent of our current democracy in 1999, in the wake of the peaceful handover of power by General Abdul Salam-led military junta to the democratically elected government of Chief Olusegun Obasanjo, also brought with it humongous dose of political aspirations to global standard of democratic governance, the benefit of which had remained elusive with the ignominious rating of Nigeria in 2000 as the most corrupt country in the world by Transparency International. The above perhaps informed the decision of the then Obasanjo-led administration to enact an act establishing in June 2000 the first anti-corruption agency known as the Independent Corrupt Practices and Other Related Offences Commission, ICPC, focusing mainly on prohibition and punishment of corrupt acts and bribery. This was followed subsequently by the enactment of the Economic and Financial Crimes Establishment Act, popularly known as EFCC Act 2004, which seeks to prevent and punish unjust enrichment. These two were further followed by Money Laundering Prohibition Act of 2011 and amended by the Money Laundering Prohibition Amendment Act of 2012, whose focus aims at prevention and punishment of acts targeted at concealment of origin of funds and assets, among others, acquired through unlawful activities. All of the above and many others considered in this paper complement the existing penal and criminal code applicable in the north and southern part of Nigeria, respectively, and the Constitution of the Federal Republic of Nigeria, as amended, which provide variously against one form of corrupt practice or the other. This paper will therefore attempt a panoramic overview of the various laws and legislative development around economic crimes and forfeiture of proceeds of crime. Now, essentially, this paper will do an overview of the updates of economic and financial crimes and the proceeds of crimes, forfeiture of proceeds of crimes. So I shall be looking at the focus of this paper in two prongs. One, the judicial updates, and then I'll move on to the legislative updates. In doing so, we'll be looking specifically at various principles or attempts by our courts in inquiring into various laws in respect of these two. Now, we know that the judiciary is one of the drivers of the anti-graft laws, and the judiciary has made quite impressive inroads into the various aspects of our economic and financial crimes and the proceeds of crimes. Now, we have seen various judicial interventions, specifically on burden of proof in assets declaration. In the case of Federal Republic of Nigeria versus Dr. Olubukola Abubakar Saraki, we saw an impressive judicial intervention where an attempt was made by forensic arguments to determine whether or not the burden the burden can shift, whether the burden can shift in the prosecution of criminal offenses. And the court stamped its feet to say that the burden remains, that the burden never shifts, whether in code of conduct or otherwise, that the body remains. And we see that the burden remains. We see that in the case of Federal Republic of Nigeria versus Olubukola Abubakar Saraki, citation provided. Now, on the constitutionality of the non-conviction-based asset forfeiture procedure, that again, the court also made an intervention in that area. In the case of Olukoya Ogungbeje versus EFCC, citation is also provided here. Popularly, the abandoned money at the Osborne Road, Ikoyi, where the court has also determined a number of issues there. And then the issue before the Court of Appeal was whether the learned trial judge had jurisdiction when he granted final forfeiture. Now the court intervened in that area, where argument was made that being criminal in nature, whether the court can exercise civil jurisdiction to grant forfeiture. And the court made an impressive extension of the frontier of law in that regard, to say that the court indeed has jurisdiction, civil jurisdiction, to make order for that forfeiture, even though the matter has some criminal element. And I think that is in tandem with the United Nations Convention of Against Corruption, UNCAC. Court made that impressive intervention to say that even in such acts with criminal elements, the court has that civil jurisdiction to make forfeiture order. And then, on standard of proof in non-conviction asset-based forfeiture, the Supreme Court, while finally putting to rest the issue of constitutionality of non-conviction-based asset forfeiture procedure, also pronounced on the standard of proof required in the trial of non-conviction-based asset forfeiture. And that case was in Dame Patience Ibifaka Jonathan versus the Federal Republic of Nigeria, citation provided. The Apex Court, in upholding the constitutionality of the non-conviction-based asset forfeiture procedure under Section 17 of the Advanced Fee Fraud Act, went on a historical voyage to consider the non-conviction-based asset recovery as an action in rem rather than in personam, and held that civil standard of proof of preponderance of evidence rather than proof beyond reasonable doubt as obtainable in criminal prosecution are applicable. Now, that is another impressive intervention where the court, the judiciary, has come in to arrest the drift, the nation's drift in corruption decadence. As stated above, the Advance Fee Fraud and other fraud-related offences Act was enacted in line with the convention wherein non-conviction-based forfeiture has been legalized by Section 17 of the Act and is not limited to Nigeria alone, as it follows the same pattern with Part 5 of the Proceeds of Crime Act 2012, POCA of the UK. It is not the procedure that matters, but the substance of the application and what is intended to achieve. The standard of proof required to invoke Section 17 of the Act and Section 19 of the Money Laundering Act, read along with Section 36(1) and 5 of the Constitution, is not proof beyond reasonable doubt, but proof on a balance of probability. We see that in the case of Daudu versus Federal Republic of Nigeria. Now, what the court has done here, or has succeeded in doing here, is that in such matters that involve forfeiture of proceeds of crime, the standard of proof is not that required in criminal proceedings, but that of balance of probability obtainable in civil proceeding. Then the time limited is too short to always go in depth in the content of this paper, but I will try. Now, on condition for freezing of a bank account under the EFCC Establishment Act, there are two major preconditions before the EFCC an account: restrain transaction in an account or attach any asset suspected to be proceeds of crime. First, there must be a prima facie case, and second, there must be a subsisting court order. Now, if you look at the combined provision of Section 42, Sub 2 of the 1999 Constitution of the Federal Republic of Nigeria, Section 28 and Section 29 of the EFCC Act, the Commission is entitled to be granted an order of interim attachment once there is a prima facie case of proceeds of crime. Now, the court has had to interpret this in the case of Jonel Integrated Services versus EFCC. The court held at page 6 to 11 as follows. Section 42, 2 of the Constitution of the Federal Republic of Nigeria allows for the grant of an order of interim attachment for the purpose of examination, investigation, or inquiry, while Section 28 and 29 of the Act, on the other hand, provides as follows. Where a person is arrested for an offense under this Act, the Commission shall immediately trace and attach all assets and properties of the person acquired as a result of such economic and financial crimes, and shall thereafter cause to be established an interim attachment order from court. Now, this appears to be in line with a personal observation I had made and also done a paper and published in The Guardian, where I suggested to EFCC that it's high time that the country should do something about the cancer that is tearing the nation in the face, and it has become an existential threat. And I advocated in that paper that there should be a paradigm shift to proof of crime in economic and financial crimes. That is, there should be proof of crime should no longer be adversarial if it has to do with financial and economic crimes. That inquisitorial method should be adopted. And I advocated that the job of the prosecutor, and I did that mindful of the fact that investigation of modern crimes is tedious, time-consuming, and resource-wasting. And in doing so, the prosecution has a very humongous burden of tracing crimes that are perpetrated this time around with sophisticated electronic platform. So what the prosecution should do is the task should be limited to tracing those acts, identify the proceeds of crime, and then invite the person to prove whether by the nature of his work or profession, he could have afforded those things. And that would help to relieve the prosecution of huge burden of having to do a whole lot of things in proof of crime. Now, I move on to the wide and unfettered power of EFCC to try all economic crimes and freeze or secure the attachment or forfeiture of proceeds of crime. In Nigeria, it may suffice to say that the EFCC has wide and unfettered power conferred on it by enabling laws to investigate and prosecute all kinds of persons, private persons or public officer, natural or juristic, and try all economic crimes, related crimes, and freeze or secure attachment or forfeiture of suspected proceeds of crime. This position was elaborately considered and settled by the Apex Court in the recent case of Nweke versus Federal Republic of Nigeria. The Learned Counsel for the appellant had argued that the Economic and Financial Crimes Commission can only investigate economic and financial crimes which relate to the activities of the government and its administration, and not private citizens. Learned Counsel for the respondent, however, disagreed and submitted that the Commission activities are not limited to government, but to all financial crimes, irrespective of their origin. Now, that is one area where the court has also made impressive intervention to say that the scope of EFCC activities is not limited to government agencies alone, but also private citizens. So as it is now, the state of the law as it is now, even in private transactions, where unjust enrichment or elements of economic and financial crimes can be found, EFCC can wade in. And now there are some other materials in that regard, but I have to run through because of the constraint of time. Now, another inherent case was the case of FRM versus Ikuforiji, citation provided, and where the Money Laundering Act was considered, and the nature of proof required in money laundering offenses by the Court of Appeal. In that case, the appellant, one Mr. Oyebode Alade Atoyebi, second accused at the trial court, stood trial before the Federal High Court on a 54 amended count charge dated 4th June 2013 for accepting various cash payments above the threshold set by the Money Laundering Prohibition Act and Money Laundering Prohibition Act of 2011 without going through financial institution. The respondent called two witnesses and tendered Exhibit P1 to Exhibit P6. After the close of the respondent case, the appellant made a no-case submission which was upheld by the learned trial court. Dissatisfied with the ruling, the respondent appealed to the Court of Appeal. The Court of Appeal set aside the decision of the trial court and held that the respondent made a prima facie case against the appellant, requiring the appellant to enter his defense. The Court of Appeal interpreted Section 1 of the Money Laundering Act 2004 and 2011 in the case of FRM versus Kufuruji as cited, and held that the offense created by Section 1 of the Act, respectively, are strict liability offenses. Their proof does not depend on approval and purposes once the amount is above the threshold amount and was not paid or received through a financial institution, either by an individual or a body corporate. The offense is complete. And so that is another intervention worthy of note by the judiciary in interpreting Money Laundering Prohibition Act. Now, there are some other contents there in relation to judicial updates. But because of time, I will now move on to the legislative development in relation to economic crimes and forfeiture of proceeds of crimes. Now, over time, there has also been a lot of legislative developments in this area. Now, we have seen the amendment to the Constitution of the Federal Republic of Nigeria. The Constitution of the Federal Republic of Nigeria, as amended, while not technically speaking a specific legislation on economic crime and forfeiture of proceeds of crime, it however contains in its general tenor and framework provisions not unconnected to economic crimes. For instance, the provisions in the 5th schedule of the Constitution of the Federal Republic of Nigeria, 1999, as amended. That is the one that has to do with Code of Conduct. Subsequent to the said amendment of the Constitution, there have been other legislative developments preserving the provisions of the 5th schedule of the Constitution. For instance, the 4th Alteration Act of 2017. Now, we'll move on to the graphic provision of the Economic and Financial Crimes Commission. 2004, vis-a-vis economic crimes and forfeiture of proceeds of crimes. The Economic and Financial Crimes Commission was established by Section 1 of the EFCC Act and is charged with enormous responsibilities, which include the investigation of 4 financial crimes, which to wit, advance fee fraud, economic money laundering, counterfeiting, illegal charges transfer, future market fraud, fraudulent encashment of negotiable instrument, computer credit card fraud, contract scam, etc. And we see that in Section 6 of the EFCC Act. Section 17 of the EFCC Act conferred the Commission with power to cause investigation to be conducted as to whether any person, corporate body, or organization has committed an offense under the Act, and B, to cause investigation to be conducted into the properties of any person if it appears to the Commission that the person's lifestyle and the extent of his property are not justified by his source of income. Now, the provision of the EFCC Act, Section 7, 1B, under reference above, is like the UK provision of Section 1 and 2 of the Criminal Offences Act 2017, which are governed by Section 262A and 362T of Part 8 of the Proceeds of Crimes Act 2002 of the United Kingdom. By the same provision in the United Kingdom, the prosecution can secure an unexplained wealth order. An unexplained wealth order is a type of order issued by a British court to compel the target to reveal the source of their unexplained order. So you can see it is not out of place. When I earlier suggested that the law should begin to head towards that direction, because corruption is posing an existential threat to the survival of this country. And it is high time the nation should also begin to copy something like this, unexplained wealth order, whereby a person's source of income is not commensurate with the person's lifestyle. And so it is not unprecedented. It is happening in more developed climes. And so it is not out of place if the country should begin to copy that too. In its quest for prosecution of economic crimes, the EFCC is charged with the responsibility of enforcing the following, and it is listed in the various EFCC Acts. Now, the consequences of violating the EFCC Act are also listed there in the paper. Now, there is also the provision in respect of asset of declaration upon arrest. And now Section 27, 1, 2, and 3 of the EFCC Act, a person arrested by the commission of an offense under the Act, such person should make a full disclosure. Now, this is one of the legislative updates, where if you are arrested, then you make a full disclosure. This is to enable the commission to determine the extent of your wealth, and it gives them other leverage in the course of the investigation. Graphic provisions of the Corruption Practices and Other Related Offences Act, that is ICPC Act of 2003, in respect of economic crimes and forfeiture of proceeds of crime. This is one area that the legislature has also tried to arrest the drift in the nation decadence in corruption. The Corrupt Practices and Other Related Offences Practice Act is another legislative put in place to check economic crimes and the violation of which attract forfeiture of the proceeds of crime. The area of legislative development introduced under the Act are captured here under. Then you have Section 12 of the ICPC Act in respect of the offense of accepting gratification. The penalty is 7 years imprisonment. There's also the provision of Section 13 of the ICPC Act in respect of the offense of corrupt offers to public officers and has penalty of 7 years. There's also the statutory provision of Section 14 of the ICPC Act in respect of the offense of corrupt demand by persons. The penalty is 7 years imprisonment, and then several others are there listed. In addition to the penalty stipulated therein, all the proceeds of their foreign friends' crimes are liable to be subject of forfeiture or payment of a fine not less than 5 times the amount or value of such gratification. Now, that is the extent to which the legislature has made intervention in the area of proceeds of crimes. Now, we look at the Money Laundering Amendment Act of 2012 in respect of economic crimes and forfeiture of proceeds of crimes. Areas of legislative development under the Act are captured under Section 15, Sub 1 and 2, and 18 of the Act. Section 1 of the Money Laundering Act provides every person or body corporate shall not, except in a transaction through a financial institution, make or accept cash payment of a sum exceeding 5 million or its equivalent in the case of an individual, or 1 or 10 million or its equivalent in the case of a body corporate. And then Section 15 of the Money Laundering Act, offense including terrorist financing, tax evasion, bribery, corruption, theft, extortion, and forgery, and many other criminal acts are specified under the Act or any other legislation in Nigeria relating to money laundering. Now, what the legislature has done here is to attempt to regulate transaction in cash. And in doing so, it has substantially, even though, of course, there will always be evasion of the law in one respect or the other, but it has substantially been able to tackle illicit transaction in cash. Graphic provision of the Code of Conduct Bureau and Tribunal Act, CCB Act of 1989, in respect of offense vis-a-vis the forfeiture of proceeds. The relevant provisions which are indirectly linked to crimes and offenses which attract forfeiture of proceeds derived therefrom under the CCB Act are relatively captured under Section 6. Under Section, okay, I'll soon be done. Yes, I'll soon be done.
All right.
Okay. Now, in rounding off, I want to thank the organizer of this conference and to say that there are various legislative intervention which time has not permitted me to discuss: the Cybercrime Prevention Act, and also the Terrorism Prevention Act as amended, and now the bill for establishment of Proceeds of Crime Recovery and Management Agency, which is still pending with the President, pending at the National Assembly. And then in doing so, I want to conclude by saying that I have not, while no attempt is made by this treatise or exhaustive discourse on the demand of this topic, it is however my hope that the above explanatory analysis usefully represent the current state of judicial updates and legislative development on economic and financial crimes, forfeiture of proceeds of crimes in Nigeria. And what I have done is to make us see an alternative view to what we have heard. Thank you very much.
Thank you very much, Tabiti, on behalf of Chief Godwin Obla. Please kindly give him another round of applause. It's wonderful to do. At this point, I will still proceed with there are so many interesting things that have been asked. And I'm sure when we take a few minutes for intervention, we'll get to the very, very scintillating aspect of this morning's engagement. If you look at page 256 to 328, you will find Wahab Shittu Esquire has rich, very scintillating paper domiciled there. Without much ado, may I call upon him to make his presentation. He has 20 minutes between now and 11:30.
Thank you, Mr. J.B. Daudu, SAN, whom I consider one of the most ingeniously dangerous lawyers in this country. In terms of robust intellect, huge brain, and contributions to our jurisprudence. We also acknowledge other co-panelists, Leonard Sik and William, my full respect. My most senior brother, Chief Michael Zekoma, SAN, for whom I have a lot of respect. And of course, Mr. Obla, Godwin Obla, we call him Obla G. I met his reputation while entering University of Lagos in 1983. He left in 83, but I met his reputation in Unilag. So I have a lot of respect for him.
Mr. Chairman, sir, do you know that I've never known that it is Shitu sitting in front of me? This Lagbaja is going to cause a lot of problems. I'm shocked. I have looked around many times to know whether Shitu is even around or was not. I'm just saying him.
Not to worry, my lord. I have a 73-page paper, well-researched paper. I recommend the paper to everybody present. But what I want to say is that, let me just briefly say that the paper, the introduction you can find on page 2 to 5. The legal framework on criminal forfeiture in Nigeria is on page 5 to 28. Issues on process of crime and criminal forfeiture is covered by at pages 28 to 33. Best practices on criminal forfeiture is at pages 33 to 34. Analysis of recent cases in Nigeria on criminal forfeiture, about 18 cases considered, recent cases, on page 34 to 58. And then I also examined the case of Gabriel Daudu versus FRN at pages 39 to 64. And I, of course, considered the recent asset trading, recovery, and management regulations at pages 64 to 68. I have some suggestions at pages 68 to 70. And my conclusion is at pages 70 to 73. That, in summary, is the paper. And I know that is an enlightening audience. So everybody seated here is qualified and eminently suited to be able to digest the gist of the paper. So I will not bother you with going through what you can as well assimilate. So I recommend the paper to you in its entirety. But having said that, I speak today in my capacity as a law officer, not as a law officer, and in my capacity as a law teacher, who has been, teaching and mentoring students in the last 15 years. And I've also been prosecuting economic and financial crime since the inception of the anti-graft agencies. So I come to this presentation armed with some of these experiences gathered in my 33 years practice as a legal practitioner in the country. So if I speak as a law officer, I've listened to the, some of the presentations, erudite presentations, and I think all the points that have been made are well taken. I want to ask us the following questions, taking my paper as read. Do we agree that corruption is our major problem in this country? I think there's no doubt about the fact that corruption, including process of crime, constitutes one of the major setbacks of this country. A giant, a country that is so rich in terms of resources, but unfortunately its people are very poor. So if we agree that corruption is a major problem, so what do we mean by corruption? Corruption is derived from the Latin verb corruptus, which means a breakdown. So when there's a breakdown in systems, a breakdown in institutions, a breakdown in societal traditions, a breakdown in ethical and moral behavior, that is corruption. So do we agree that we need to fight corruption? Of course, there's no dispute that if we want this country to progress, then we need to fight corruption. Then again, how do we fight corruption? My view as a law officer is that corruption must be fought in the context of respect for the rule of law. And that's my view, and that's where I stand. How do we deal? Those accused of corruption, are they entitled to legal representation? Or do we label those who defend suspects of corruption? My view is that we should not label them. Those accused of corruption are entitled to legal representation. So elements like Chief Michael Zekome are entitled to defend them. And they are entitled to earn fat money in the process. So I have no quarrel about it. Now, Again, do we label anti-corruption those who are fighting anti-corruption war on behalf of the rest of us? I think it's also uncharitable to label them. Very, very uncharitable, because what they are doing is a human service. It's not easy to fight corruption. When you fight corruption in a country as corrupt, fabulous, fantastically corrupt as Nigeria, what you attract for yourself are enemies. You cannot fight corruption and be the friends of the people, because corruption is very embedded in our social fabric. And all of us have agreed, including Chibako, has agreed that corruption is really the bane of our society. Some elements like Magu, who is my client, I'm not here holding his brief, should not be maligned for sacrifice. There's no individual in the history of this country that has investigated corruption as much as Ibrahim Magu. There's no individual. And Ibrahim Magu has been investigating corruption since the inception of anti-graft agencies in 2004 up till now. And he's suffered, he's been imprisoned, he's been taken into custody, he has suffered a lot of deprivation for doing this. And one thing which is clear is that in terms of record of performance, there's no administration that has achieved more in terms of fighting anti-corruption than the Magu-led EFCC. And the records are there. In terms of recoveries, in terms of convictions, his achievements remain very stellar. So, I agree that some people may have cause not to query some of his methods. That's why we are lawyers. And that is why I'm particularly happy that this forum is tagged rule of law foundation. EFCC, ICPC, all the anti-graft agencies are set up by law. So no individual is entitled to say he's above the law. So if the anti-graft agencies are carrying out their operations outside the purview of the law, that is a challenge to lawyers. You don't come here and start groaning or lamenting when you can challenge whatever excesses the anti-graft agencies commit in the law court. And Magu has not made any representation to say he is above the law. EFCC is created by law. ICPC is created by law. Code of conduct is created by law. All the anti-graft agencies are created by law. So rather than label Mr. Ibrahim Magu or anybody who is sacrificing his life to fight corruption, including the prosecutors, why don't you have recourse to the court of law and behave like a Ghanaian who fought the system through in the instrumentality of the rule of law? And that is why it's celebrated up to today. And I dare say that is the direction JBWSA is heading to. When you entrench worthy legacies in the fabric of a country, you remain unforgotten. So I will challenge Chief Michael Zeko, for whom I have a lot of respect, to have recourse to the court of law. For instance, Magu, who has been a center of a boot of criticism today, is not here. If you look at what has been happening to Magu, it should worry you. When we are talking of rule of law, we should insist on respect for the rule of law, even when our enemies are involved. Even when our enemies are involved. So it's not an excuse to say, oh, Magu is having a taste of self medicine. Who is Magu? When there is rule of law. But the point that is very, very important today is that we have a judicial commission of inquiry being constituted by federal government to investigate assets connected, concerning EFCC, which covers the entire country. That obviously is an illegality. The federal government cannot set up a judicial commission of inquiry to investigate EFCC, which covers the entire country, because it's a prerogative that is reserved for the states. I expect Chief Michael Zeko to have spoken out, because that is a certain area. The federal government cannot set up a judicial commission of inquiry. I know. What I'm saying is that, you see, I'm saying that all this debate can be reduced into one thing, one fundamental principle that you and I and all of us here subscribe to. What is that fundamental principle? Respect for the rule of law. And again, let me remind everyone here that we operate a democracy which is anchored on the rule of law. And there are fundamentals of the democratic tradition. Respect for the rule of law, respect for constitutionalism, respect for due process, respect for fundamental rights. These are the fundamentals of the democratic tradition. Why can we say we are practicing democracy if we are not prepared to be Democrats? So if there's any complaint about the activities of anti-graft agencies, and I take this position seriously, because it's turn by turn Nigeria Limited. It can be anybody's turn. Let us insist that rule of law must be upheld, no matter who is involved, whether our friends or our enemies. That's the position I have taken. Secondly, you see an Attorney General of the Federation, Chief Law Officer of the Federation, who is served a subpoena by a judicial commission of inquiry which he put in place to come and testify. And he refused to come. The Chief Law Officer of the Federation refusing to answer to a subpoena. And I've seen people keep quiet all over. Again, you have Section 33 of the EFCC Act, which vests the sale of forfeited assets on the EFCC or the anti-graft agencies. And you find an Attorney General who is now constituting a committee to sell forfeited assets. That clearly is illegal. It's unconstitutional. I've not heard the voices of Chief Michael Ozekhome in respect of this. Maybe because the person who is involved is Magu. Again, you have asset tracing regulation being put in place for disposal of assets at the behest of the Attorney General. Of course, you all know that it is elementary learning that regulation cannot supplant the law. So the regulations that are put in place by the Attorney General, he can regulate, but to sell, that is illegal. So you find a lot of illegalities being perpetrated here and there. But we keep quiet because we believe our enemies are involved. Ibrahim Magu, let me correct that, remains the suspended acting chairman of EFCC. He has not been removed. I was part of the proceedings from the beginning of the Salami-led panel. And it will shock you to note that all the allegations against Magu collapsed completely. They said he was laundering money through BDC, that collapsed. They said he bought property in Dubai, that collapsed. You will find, and I challenge you, you will find that there will be no finding of corrupt enrichment against Magu. There will be no finding that the man dipped his hands into your till. And if somebody has been investigating corruption for close to 16 years, you go to see his house in Cairo. You cannot find any illicit arrangement with Magu. The problem with Magu is that you cannot penetrate him. You understand me? The only way you can fight Magu is to have recourse to the rule of law. That's the way to deal with a person like that. If you believe somebody, you can. If you say you cannot, but to say that you want to rubbish the efforts that Magu has made for this country because of methodology, which you can challenge. You don't throw away the baby with the bathwater. I came out to defend Magu, not for financial reasons. Yes, it is true. I defended him, and I still believe in him. Of course, if I were to advise, I would say, okay, fight corruption in the context of the rule of law. That's the only thing I would tell him. But in terms of passion for fighting corruption, Magu remains, his performance remains very stellar. Stellar. And the records are there. And when I came in to defend Magu, I told the Salami panel, I said, my appearance of Magu is conditional. I said, if you show me today that he has dipped his hands into public till, evidence of corruption, if you show it to me this minute, I will withdraw my appearance. That was my first challenge to the party. And when I was running up his defense, I also repeated it. I've examined all the 111 SCB standard before all of you. I've not seen anywhere this man stole assets. So tell me now, if you show me this minute that this man is corrupt, I will still withdraw. Silence. But what I've seen clearly is that the man has stepped on so many powerful toes. And those toes are very powerful. And those toes are revolting. Understandably. Because the only thing going for Magu is his innocence. So what I'm saying is that as regards the subject matter of this presentation, which I tried to adopt this approach in view of massive onslaught, massive attacks on the person of Magu while I'm seated here. While Magu is not even here to defend himself. And go and check the records. We are lawyers. We should not base our conclusions on sentiments. Check the records. In terms of recoveries, in the history of this country, has anybody posted the kind of achievements Magu has posted? In terms of convictions, has anybody posted any record compared to Magu? Those are the questions. Okay, if you now want to remove him, of course, Magu can be removed. Anybody can be removed. Magu is not the only one who can fight corruption. But what we are saying is that follow the rule of law. Follow what? The rule of law. You don't arrest somebody on the street and match him before a panel without access to documents, without access to copies of the allegations, and then you say, okay, you have to defend yourself. Again, up till now, copies of the allegations was not furnished to Magu. That should worry us, including Chief Michael Zakome. The terms of reference of the Salami-led panel was not given to that panel until 35 days later. That should worry you, including Chief Michael Zakome. Again, by virtue of the law setting up that tribunal, that commission of inquiry, witnesses are supposed to be sworn on oath. All the witnesses who testify, including Chief Michael Zakome, was never sworn on oath. It was also supposed to be public sitting. All of you do not have access to this. What kind of? The only I'm telling you is that is what should worry us. Not to say, oh, Magu, I've seen some approach. Oh, you're having a taste of your own medicine. Now you're having it. You now see what it is. I don't think that should be the argument. The argument should be everybody is entitled to the protection of the law and adherence to the rule of law. Let me tell you very frankly, this country is richly endowed in terms of everything. In terms of everything. What is our problem in this country? It's corruption and impunity. Those are our problems. That is our problems. You understand me? If you go to developed economies, Nigerians are developing, they are making waves all over the place. My first son is a medical doctor. So, Daddy, I cannot say, he's here in UK now. Serving other countries. And the elements like that. That should worry us. You are talking of process of crime. And I want to refer you to page 47 and to page 49 of my presentation. You will see that I've clearly articulated about 20 principles that are settled by our courts. EFCC is an investigative and a prosecutorial agency. Abi? EFCC is not an educating agency. I know Chief Michael Ogizokome has gone to court severally and obtained judgment from the court against EFCC. If they don't obey, file contempt proceedings.
Why shouldn't they obey?
If they don't, I have also been saying. I'm talking publicly. I'm talking publicly now. I'm talking public. You see, you know that on a personal level, I have unparalleled respect for you as one of the most brilliant lawyers in this country. What EFCC has also provided is a platform for Chief Michael Ogizokome and the rest to vibrate jurisprudentially and make a lot of money. So what is important, you see, let us avoid, for instance, on sentimental grounds, if matters affect people I consider my friends, I feel for them. Because it can be my turn too. You understand what I'm saying? And I think I've also asked Kebagu to take some lessons. You understand me? On the need to respect the rule of law. You're in the fight against, which is the point you are making. But what I'm saying is that don't label Magu the same way you don't expect yourself to be labeled for defending people who are obsessed with the theory of corruption. What is good for the goose is good for what? Gander. You are a respected person. You have just said it here now. That you have 5 columns weekly. That is robust jurisprudence. Imagine deploying all that your energy and talents in fighting the war against corruption. I mean. No, I said, we will be happy to have you.
I cannot protect
No, what I'm saying is that, I'm saying to defend. I'm saying that you are so talented that it will also be useful to have elements like you on our side. So, you see, what I'm saying, in rounding up, let me say that I want to conclude by saying that the process of crime bill should be assented to in order to harmonize all the process of crime legislation in Nigeria. I think that should be a takeaway. Secondly, we also have to conclude that the Attorney General cannot set up a committee, a party-led SAN committee, to sell forfeited assets. That is illegal. If you look at the Section 33 of the EFCC Act, we vest the right to sell on that. If you are not comfortable with that legislative framework, what you need to do is to amend the law. You cannot say you say he's relying on presidential directive. A presidential directive cannot supplant the law. That's elementary. So what I'm saying, concluding is that yes, assets that are recovered ought not to be looted. That means that places the burden of fighting corruption on all of us. EFCC, ICPC, Code of Conduct, on all the anti-graft agencies exists for all of us, including Chief Michael Ogizokome. All these bodies exist for all of us. They cannot be superior to our constitution. They cannot be superior to the rule of law because they are also set up by law. So what that means, what that calls on us is that it's for all of us to be the watchdogs. All of us here. You should enlist us in the war against corruption because it's everybody's business. Who is happy with the massively corrupt society that we're on today? Who is happy in this gathering? Something must be done. Magu is not the problem. It's indeed part of the solution. I thank you for inviting me.
Magu is also not the topic of our discussion here.
No, I've said so. I've adopted my presentation in total. Why I had to go into details like this is because
during this meeting I'm presiding.
yes.
So the third part is relevant and not relevant. And I thank have Shitu for his own insight and approach on the issue. And I rule that everything he has said is relevant to what we are discussing. Because he is here, he has the right to respond, and we have the right to also have a robust engagement on this issue. These are intellectual matters. Nobody should feel offended. It shows the unique nature and platform and environment that we have in Nigeria, where we enjoy the freedom of expression. The beauty of it is once you do not take away the Audi alternate pattern group, then we're okay, we're fine. Everybody will have his turn to comment, to respond, only that let us keep things within the bound of the decency of our profession and the honor associated with it. I took notes when everybody was speaking. I have at least 6 pages of notes. The time will not permit us to go through it because we are to round up at 12 o'clock. I take it that everybody has had an opportunity to express himself, and we understand.
Mr. Chairman, Mr. Chairman, sir. Mr. Chairman, sir, please, with all respect, I have a right of reply. Mr. Shitu mentioned my name 21 times in his presentation. I mentioned Mago 25 times. In my presentation, I only mentioned Mago once when I said Nigerians should give him the opportunity to be heard and to be treated decently. I focus mainly on recommendations. So, Mr. President, sir, or Mr. Chairman, sir, I have a right of reply so that people do not live here with certain wrong notions. And my reply, yes, sir.
The point is this. The pattern in which it has followed is every presenter has made his
no, not dwelling on personalities. Mr. Chairman, sir, he has mentioned my name 21 times. I have a right of reply. And I will not take more than 5 minutes just to debunk some of the insinuations. Please.
Weak opportunity. It is the timing of the opportunity because we are following a scheduled program. We still have 20 minutes. What we want to do, and I have not made any comments on the notes I've made. I do have the right to intervene. So what I want to do is to give everybody an opportunity. When we are taking 3 or 4 people from the floor or from the Zoom meeting who have raised their hands, I will now come back to the presenters and they give their final word. At that point in time, you'll be able to clear 1 or 2 areas before I close the meeting. Is that acceptable?
Mr. Chair, our lunch is even late, so you can extend by 15 minutes. Our lunch
no problem.
Okay.
Oh, it's not late.
It's running late, so you can add some time.
Yes. I will pass it to you, the moderator, yes, to take people from the floor who want to make comments. When you are due with 4 people or 5, then we come back and we take the responses. And I will start with Michael Zekome and end with Dan Awelu before I close the meeting. Is that okay? So, Paul, you can invite people from the floor to make their contribution.
Sorry,
once that is done, I go back to the...
So, can we have the roaming microphone and somebody from Cogito can help me with the mic? So please, if you want to make have any question or contribution, we have 2 minutes. 2 minutes. 2 minutes because of time. Yes, we also have those on Zoom. So please, can our technical people let me know if we have anybody on Zoom who wants to contribute? Please, your time is 2 minutes. 2 minutes. If you have a question, does anybody in the audience have a question? Seems we don't have any question. I would have thought I would have had definite questions on these very topical issues raised.
My brother, that there's nothing.
If not, I will hand over back to the chairman. At least that saves us.
Please. Okay.
Yes, you can.
Very quickly, is the suspicion of unexplained wealth enough probable cause to seize or arrest?
Okay, is that directed to all the panelists? Or okay.
I mean, particularly to my friend sitting to my right.
Oh, okay.
Yeah, exactly.
On unexplained wealth.
Is that enough probable cause to seize or arrest?
I want also to add to your question. And my point is this. Even the words choosing, when he was discussing that, I put it down here, unexplained wealth simply means there has not yet, it has not yet been established the source of that wealth. Are you getting my point? That's why it is unexplained. And therefore, the presumption we talked about earlier on comes in under section 36. That when you say it is unexplained, it means it has not been ascertained the source of the wealth. And it comes back to, because what we are discussing today is forfeiture of proceeds of crime, economic crime. Before you begin to arrest, investigate. Let me even touch an aspect of that issue of investigation. I do appreciate the intellectual rigor put in by Obla SN. But in my own view, we still have inadequate capacity to investigate. I think you are the one that mentioned that abroad, the day the security agencies invite you, know that they have concluded the investigation. The contrary is here, and I mentioned it on Monday. Here you are arrested, you make your statement, whether confessional or otherwise. Next, you are charged to court. And on being charged to court, all the networks, television, radio, everybody is there. And it is shown. There is even worrying aspect of immediate past governor of Kaduna State, Ramalan Yero, who was published. He held up, put his name, and being suspected of having, then they started the crime, and he was in his incomplete attire. Let me not go into details, and was holding it like this along with others. We haven't had anything from that case again. It hasn't been charged to court, nothing has happened again. Now, when you are talking about unexplained, the proper thing in line with the court's decision that we analyzed today would have been, you are brought, they would have done their background investigation, trying to link the assets in question by their own forensic investigation to the person that acquired it and the time of acquisition. Once there's a linkage, then you begin to invite the person. But if you say on the basis of unexplained wealth, you go to court, get interim order, confiscate, before you now ask the person, come and explain. I thought that is putting the cart before the horse. And section 36, another aspect of the concern is there. Thank you.
May I take...
Has the question be answered?
If Mike is echoing.
I thought the question was directed at me.
I just want to caution that there's no big bad to me. I too have my own comments on some of the things that have been said. I think some light has to be shed on it. We're all working towards the same objective, and perhaps I note a point that Wahab Shitu made. He used the word methodology, that Magu's methodology may have been questionable at times. The disclosure of information to the press, the use of Sahara reporters, those are in the main what people are talking about. The assumption that somebody is guilty. There was some exuberance we're not questioning the motive that he didn't mean well. He may mean well to carry the wrong procedure. Just like at times we are not happy with decisions of the Supreme Court. So you have seen that the methodology and what people are saying, without prejudice to what Chief Mike Ozekome's response will be on board being fair, is that when the shoe is now on the other foot, we take this response as you now appreciate what other people felt. Myself, Chief Obla, Isu Kala, were tried on the pages of newspapers that we collected over $290 million of Halliburton money meant for the federal government, and we disappeared it. The same accuser knew that this money was in the federal government coffers and that our fees had not even been paid. Yet, every newspaper carried it and portrayed us former NBA president. I have not. We went to court. We have dealt with it in court like we should do. But at times we are human, and we cannot, as human, not say, oh, this is this kind of poetic justice, because we have not finished going through the emotions of everything, and rightly or wrongly, it's happening to the man who made a mess of us. But we are mature. We are not wishing him evil. We're only saying that for people in future to learn that there is a need to follow due process, need to follow the rule of law, need to follow, respect the human rights of people when you are in such sensitive positions of public authority. And that we didn't even expect that the government who brought him in will be the ones to do it. We thought perhaps a later government might investigate some of these things happening in his appointing administration ought to give us some cause for reflection. So that's why nobody is maligning your clients. If things happen, it is the system. That's why we are saying we should build strong institutions in this country and not strong men. Magu, no doubt, is a strong man, but his zeal apparently has now put him in trouble. Well, I pray that he comes out of it unscathed. Chief Michael Zekome, you have the floor.
Yeah, thank you, Mr. Chairman. I'm happy that Shitu came here to do two main jobs. One, to defend Magu, which she should have done before the Salami panel, or challenge the Salami panel if he felt certain things were going wrong by going to court. But funnily, he is saying that it is Michael Zekome who should have challenged the Salami panel, challenged the Attorney General for allegedly doing certain wrong things, when he is the lawyer to Magu and is being paid handsomely for doing the job. So if he has not done that, it means he has failed woefully in defending Magu as his lawyer. If he knows certain things that were wrong and he did not, it means he has failed woefully. So one major thing Shitu came to do here today is to defend Magu before this panel, because I can tell you, Mr. Chairman, sir, I'm aware that many Magu boys and journalists are here and they wanted to have something to report, to take away. So take it to them and go and tell them that Shitu came here to defend Magu and then to attack Chief Michael Zekome. But I will not. I will not reply in that something. Shitu, you were there when I first appeared before the Salami panel on the 28th of January, of July, you were sitting down. Magu and myself greeted. He said, my friend before. And I told him, my friend forever. When I was testifying, I told Justice Salami Panel that Magu is sitting down here, that he was the one who invited me to one of the seminars. And when some people did not want me to talk, he insisted that I must speak. I said it. Mr. Chairman, sir, when Magu was arrested on the 7th, I think on the 7th of July, the following day, 8th of July, I put out this statement. It's reported in Nation newspaper, Sahara, Daily Post, Punch, Sun, all the major papers and online. I say, Nigerians, I beg you, don't do to Magu what he did to others. Human rights lawyer, Chief Michael Zekome, has pleaded with Nigerians and those in authority never to accord Magu, the suspended acting chairman of the EFCC, the same treatment he gave to others, or the same shameless media trial as he, Magu, did with most public officers accused of corruption. The senior advocate also said that the former EFCC boss must be presumed innocent until he has been subjected to the due process of law through a free and fair public trial. The fact that he did it to others did not and does not make it right. Two wrongs can never make a right. As I have argued again and again, like a broken record, the anti-corruption war was never a regenerative and ethics-defining regimental war. It was purely a score settler against rights activists, the opposition, public critics, plural voices, and dissenters. I was begging, the very following day, I was begging Nigerians, I said, please accord Magu fair hearing, decency, respect his position. So I am never the kind of person who will go after the jugular of a person because he has issues. Now, before the Salami Panel, the second time, I came there, they could not hear me. They said I should merely tender my documents. I tendered, I gave to them, and I left. I didn't say anything. Some lawyers employed by Magu started attacking me in the press. I refused to dignify them with a reply because my records were put out there. I wrote 84 pages. I sent 32 files. I sent 215 exhibits. I sent 8 videos. I made 33 recommendations because it was not about Magu. And I told him in the presence of Shitu, I said, if it were possible to talk about this corruption, anti-corruption war without mentioning Magu, I would have been too happy. But unfortunately, Magu equated the war with himself. You could not separate them. They became Siamese twins. It's like a futile attempt to separate Hamlet from the Prince of Denmark, or to say that 6 is different from half a dozen. It's like saying you hate beans, but your best food is moi and akara. It's like the story told by the Ghanaian writer Ayikwe Ama in his book, The Beautiful Ones Are Not Yet Born, concerning a bird called Chichidodo. The bird hates human excrement with all his heart, but he feeds on maggots that wriggle out of decaying human excrement. So when Shitu is saying, oh, we challenge them to share how Magu has dipped his hands into the public tea, they could not show. That is Mr. Shitu's own circumscribed and very, very narrow understanding of the concept of corruption. Because like the government he is serving, they seem to believe that corruption is only in the giving and taking of money. And you say you will advise Magu to observe rule of law and do things within the legal organogram. That is all I'll be saying. That was why I said fighting corruption and respecting fundamental rights and rule of law are not mutually exclusive. That is all I'll be saying. I have always said fight corruption, but do it within the legal regime of our country. But what Magu was doing was that he was fighting corruption with bare knuckles, disgracing people, dragging them on the bare floor, detaining people without trial on end, disobeying court orders, writing to banks to threaten them with closure. If they paid money to my clients, money ordered returned to my clients, Patient Jonathan, specifically after argument in court between me and their lawyers, they will write, and the bank will write to me and say, sorry sir, we wanted to pay you, but we just have a letter from Magu and from his boys that we should not pay, and if we pay, they will close us down. We are sorry, we cannot pay, sir. Is that how to you were fighting corruption with a worse form of corruption, and that is why you never achieve results, and that is why we are where we are. Governor Fayose of Ekiti State had his account frozen. We did the right thing. We went to court before the Federal High Court at Ekiti. We challenged the forfeiture and said you could not have issued court proceedings against Fayose because of Section 308 of the 1999 Constitution. Their lawyer argued for 4.5 hours. I argued for 4.5 hours. In fact, I first argued for 4.5 hours. His lawyer said he must also use the same 4.5 hours. After listening to us, the judge vacated the freezing order and released the money. You are all here, you all watched it. Fayose went to the bank, Zenith Bank, and withdrew 5 million naira for himself and even displayed it to the world. Then from there, I was handling 10 cases for Fayose because they were traducing him from everywhere. From there, he sent me 75 million naira as part payment of my professional fees. For God's sake, I'm in the same age bracket with Dangote, the richest man in Africa for over 10 years. I mean, so some 75 million, Dangote can sit down and write a check of 50 billion naira. And this was based on my sweat as a lawyer, handling 10 cases. What did the FCC do under Magu? They went and seized and froze my account of 75 million naira, paid to me as professional fees. I gave them 7 days ultimatum to defreeze my account or I will go to court. They refused. I went to the Federal High Court, Lagos, before Justice Abdulaziz Anka, who listened to arguments after 4 months proceedings and ordered the account defrozen, and I withdrew my 75 million naira quietly. Is that how to fight corruption? Do you fight corruption? So when you are talking about my government should go to court, oh, Shitu, that is all I'll be doing. I'll be going to court, I'll challenge the EFCC. By the grace of God, I've won 95% of the cases. I don't have a gun. I don't believe in violence. I've been speaking, writing 5 columns. So you, defending Magu, thank God you say when you have the opportunity to advise him, tell him, if in future, in another world, he has an opportunity, he should do his job with the fear of God. He should fight corruption with the fear of God. He should not name and shame people. He should not detain people unjustly. He should not leak information being given by a suspect to the public. All these are what I have been saying. Martin Yemola, Mr. Chairman, he was a German cleric. He witnessed the atrocities during the World War II between 1940 and 1945. He noticed that a lot of people were not saying anything. Then he said the following immortal words. He said, first, they came for the socialists. I did not speak because I was not a socialist. Then they came for the communists. I did not speak because I was not a communist. Then they came for the trade unionists. I did not speak because I was not a trade unionist. Then they came for the Catholics. I did not speak because I was not a Catholic. Then they came for me. And by then it was too late. There was no one left to speak for me. The point I've been making to Magu is what is now happening to him. Build strong institutions and not strong men. Soldiers go, soldiers come, barracks remain. Magu has been suspended now since July 7th. There's one acting chairman for EFCC, one Mr. Umar. Has Nigeria collapsed? Ladies and gentlemen, that is just the point I've been making. So please, don't make it me versus Magu. I have nothing against him. If you look at all my writes up, I never mentioned any other person. And like I said that day, I only mentioned him because he approximated the war against corruption. And if you fight a war against corruption, you should be above board, like Caesar's wife. I'm not the Attorney General who charged you with about 22 violations. I don't work in government, so I cannot go to court and defend a person who has not obtained my services as his lawyer. Shitu, you should do that. And where you have failed to do that, it means you have failed your client. And you should take remedial steps. If you were abroad, your clients will sue you for professional negligence, knowing that you should have done this and you did not do it. And then you are trying to heap the blame on another person. And finally, Mr. Chairman, sir, finally, sir, I still maintain, don't label people merely accused of corruption as corrupt people. Don't name and shame. Thank you, at least thank you, Shitu, you agreed on one thing. I told to defend a client is the carte blanche rule. When I hear people say Gani Fawehinmi never defended people accused of corruption, I laugh at them. I was Gani's deputy by 1985. By 1983, I was a senior lawyer. My salary was beautiful, 300 naira a month. When I became his deputy in 1985, he increased it to 500 naira. I set up the Nigerian Weekly Law Report on October 1, 1985. I was assistant editor from part 1 to part 12. Gani Fawehinmi defended me before the Justice Efanga Commission of Inquiry regarding people accused of grand corruption, larceny, and economic sabotage. He led me to defend Alhaji Ibrahim Diko against people accused of grand larceny, corruption, and economic sabotage. He led me in Abuja here, when Abuja had only one small guest in. I was staying in with Adek Tokumbo in Suleja anytime we came, to defend Alhaji Majid Dadi and others accused of grand larceny, corruption, and economic sabotage. He led me to defend the former director of NYC, Colonel Obasa, and his deputy, Chief Killer. Colonel Obasa was jailed for life. Chief Killer for 25 years. They were accused of corruption and grand larceny and economic sabotage. When I asked Gani, when people challenge Gani, why are you doing that? He cited Section 36 of the 1979 Constitution, which is now Section 36 of the 1999. He said they have a right to defend themselves, and that the NBA cannot tell me who to defend or who not to defend. Because of that, NBA blacklisted Gani and put his name in a role of dishonor. For years, Gani refused to apply for sanship. He told me, Zek Baba, they can put it in a briefcase and throw it into the river. On the 22nd of November 2000, I went to Gani Fawehinmi and knelt down. I said, sir, apply for sanship, because if you don't, I will never apply. I cannot be in a situation where I will sit in front and you are at the back. Gani wept, and I wept. When I released my memos, Nigeria will see. And that was why in 2001, he applied for it and got sanship. It was only in 2002 I started applying. So let nobody come and do historical revisionism. People like me will not accept it because the facts are there. So just Google Ozekome Magu. You will see all the times I challenged Magu, and all I was telling him was fight this corruption within our legal organogram and rule of law. Ask him frontally. So yes, sir. So Mr. Chairman,
I think
yes,
Mr. Chairman, just one something. One comment. I like to put it on record that I have the greatest respect for Chief Michael Ozekome. I'm sure he realizes that the tribute I did on him remains one of the most stellar tributes up to date.
Agree.
Am I right?
Very well.
So this thing is not personal. I have a lot of respect for you.
No, you mentioned me 21
No,
times.
no, I mean,
So that made it too personal.
no, no,
21 times.
It's not personal. Well, I think the summary of my presentation, the summary of what I'm saying is that whether it's Magu or Chief Mike Ozekume that is involved, we should insist as lawyers on respect for the rule of law.
Exactly. That's all. And that's all I'll be saying.
Gentlemen,
Mr. Chairman, we have some questions of-
session, and that apparently I knew from this position that both legal luminaries were on the same page. Because you know, when we go to court, the judges of the courts refer to us as ministers of justice. Yet, we speak from the perspective of our clients' cases, because there are so many to look at the same thing. But glad that it's been a very robust discussion, and that we have anchored successfully at this safe harbor. There are some questions online. I'd just like to read them, and whichever of the presenters find it relevant to his presentation can deal with it. There is an anonymous attendee who said law firms were exempted by virtue of Federal High Court judgment by Justice Gabriel Kolaole, now Justice of the Court of Appeal, which appellate court upheld
Confirmed, yeah.
from school registration requirement. That is to say that law firms subject to extra professional regulation, that is regulation outside the legal profession by agencies like school. And there is this judgment which I think Chief Oladipekun argued, and Justice Saboki, JC as he then was, gave a judgment. However, whoever wants to answer it, there's another question that, okay, it says the same question. However, EFCC has just relisted farms again. Why is it so difficult to adhere to the rule of law and obey court orders and judgments? So that's the first one. The second one is from Benjamin Atanu Achimudu. And he says it is a fact that one of the challenges in criminal justice administration in Nigeria remains that of protracted delay in the prosecution of cases. In maritime cases, for example, the delay often occasions huge economic losses to investors and stakeholders. In particular, the delay, among other, results in heavy burden of having to maintain and secure arrested vessels exhibited by the Nigerian Navy. Nigerian vessels exhibits by the Nigerian Navy, the lead maritime law enforcement agency in Nigeria. Sometimes the arrested vessels, products, and exhibits get severely degraded or destroyed before conclusion of trial. As a way out, it is suggested that the EFCC or other prosecuting agencies should consider, in deserving circumstances, the option of interim orders for the sale of arrested vessels and products pending prosecution. The proceeds could be kept in the designated interest-yielding account and should be returned to the owners of the vessels accused persons or forfeited to the federal government depending on outcome of trial. So please note those two questions. Then my own, with respect, if you permit me, intervention on this issue of interim forfeiture and interim attachment. Now, I take it quite seriously. I think we have a few minutes. The judgments which Mr. Biti referred to, which Wahab Shitu cited copiously on this issue. And the two principal cases of Patience Jonathan and Oti appear, in my view, with the greatest respect to the Supreme Court and the Court of Appeal that has followed those judgments, to be a derogation from the Constitution. Now, I understand perfectly that from Jonathan, the Supreme Court ran into a hitch. This is an interim order forfeiting a large amount of money to the federal government. Yet, no charges have been filed. There was no prospect of a charge being filed. Mrs. Jonathan herself was not a public officer or the wife of the president. The president himself was not charged. And therefore, what was then the basis of the forfeiture, either interim or final? Now, we run to this problem of, indeed, whether a court should be a court of justice, of law, or policy. When you have a situation where the law says, especially in section 44, and it requires conviction before you can adjudge or direct or order a property as forfeited, it then becomes mind-boggling. Because, let me just read that out. It says, nothing in subsection 1 of this section shall be construed as affecting any general law. B, for the imposition of penalties or forfeitures for the breach of any law whether under civil process or after conviction for an offense. So the Constitution presumes that there must be a trial and a conviction before the issue of forfeiture comes into play. However, because the Supreme Court has seen this part, they chose the first option, which is whether under civil process and then disjunctive or after conviction. That forfeitures under Section 17 of the Advanced Fee Fraud Act are forfeitures that are civil in nature, with profound respect. That is sophisticated. There is nothing civil about an act which penalizes a conduct as advanced fee fraud. It is a criminal or penal statute. Charges are expected to be filed under that legislation for it to activate Section 17. For Section 17 to be taken out of the context of the entire act is part of the things we are talking about, of picking and choosing and not following the rule of law. The entire problem arises, in my view, from the misnomer, the use of the word interim forfeiture. If I was sitting on the Supreme Court bench or any other Supreme Court bench, I will not allow that terminology when there has been no conviction. This is because, definitely, what is intended is a preservatory order or an interim attachment, as rightly used in the EFCC legislation. The word forfeiture displaces the use of the word interim or final. Forfeiture is a post-conviction activity anywhere in the world. It means you lose your right to those assets and they're forever gone. There can be nothing interim in forfeiture. So the use of that word is what has created confusion. In England, where we borrowed the idea of interim preservation or interim attachment, it is a situation whereby these monies are kept, the owner's families are fed from it, his legal fees are paid from it, the prosecution pays themselves the cost of it, At the end of the day, if his money remains and he wins, he gets the change. His livelihood does not stop. But like Daniel Olum has shown, in our situation, they even appoint caretakers and managers for a property acquired when 10 years even before you went into government political office. So this is an issue that, on my own personal view, we need to call upon the Supreme Court at the appropriate time to take a greater look at this. You see, Supreme Court was quick in Udogu Jones, Ojikalu's case, to say that the Administration of Criminal Justice Act could not override the Constitution, and that the Constitution is supreme, and any law that is in conflict with the Constitution is void to the extent of inconsistency, and refuse to be bound by the policy which they highlighted in Shema against FRM, that the Supreme Court or the courts should join the executive in fighting the scourge of corruption. I've always said that the functions and the duties of our courts is not to fight corruption. It is to do justice impartially among all the parties. Section 6 allows all government, empowers the courts to do justice or to hear cases between citizens of government, and between government interstate. Everybody is equal before the law. But when you have policy judgments, like in Shema, which says that federal government or the judiciary should join the federal government in fighting corruption, it shows quite clearly that the judiciary has taken sides. It is not the judiciary's business to fight corruption. Their business is to do justice according to the law. In Udogu, they did the right thing. Now, on forfeiture cases, they have decided to fall back on their policy. A court, like the Apex Court, cannot be allowed to blow hot and cold on different occasions. In one breath, you say a statute, a National Assembly statute, cannot override the Constitution. On forfeitures, the Advanced Fee Fraud Act is elevated above the Constitution, above the presumption of innocence, above, Agwiti says it should be reversed. Until it is reversed, that continues to be the law. The law is that a Nigerian or a person charged to court in Nigeria is presumed innocent until proven guilty. What is the rationale of seizing his property while that presumption is extant? So I think that we have put ourselves in a lot of mess. And finally, I would just like to say that the Bribery Act is still pending in the National Assembly. I think this is for Senator Ogde's man there. The Proceeds of Crime Act is still pending. I know why there is reluctance to pass the Bribery Act, because a lot of people, if applied dispassionately, will have to build at least 3 more prisons every state in this country. So those 2 legislations should be passed. Defense lawyers are not against people being charged and tried. We don't delay cases. In fact, the faster the cases are had, the better. This is just our profession. It's just like you have been blaming an undertaker for working in such somber profession, because it has to do with people disposing of people who are passed on. So, as unalluring, as hard, difficult as this work may be, it is for the greater good. And I will use this opportunity. This is what is quintessential law practice. This is what we do in court every day. We face ourselves, exchange points, but at the end of the day, you saw Chief Michael Vekome and Wahab Shitu smiling and laughing. Don't be surprised they go out together and have lunch. then their client will be wondering what has happened.
She too is my aburo. When we leave here now, we go and eat together. It's my aburo. He wrote one of the best tributes ever for me when I was 60, as he said earlier, and I thanked him. Yeah.
Yes, only that this.
So everything he was saying today, he was trying to, he doesn't believe in them.
That's our everyday business. We meet, we exchange views, we exchange big bats. At the end of the day, we are one. I just like to confirm from Paul whether there's still anything left, or do I bring this?
Yes, I have one more question, and then they have to respond to the questions that were raised. There's another question. They said this person is interested in the right of a co-owner of a property that has been forfeited. Is such a person's right to own property also not infringed? So the person is Anselm Obarize. He wanted a response to that.
I can answer that. It's very simple. I've done about 12 cases like that. A property is being forfeited and is co-owned by another person, or is adjacent to another property, and because of that they forfeit both of them. Just go to court, the same court that did the interim forfeiture, and put your facts before the court. Now there's a mistake here. A is not the owner of this property. It's owned by a company. He's just one of the directors of that company. We are also directors. Or the other property is just merely adjacent to that one. It is not their own. And by the grace of God, I've got all such interim forfeitures reversed. So that's just the answer. Go to court. The same court that did the interim forfeiture with facts, figures, and data. And the court will listen to you. I've always done all my own in court too. I will not use the media. I don't do my trial in the media.
Sorry, just to add what Chief Osoken has said. The question underscores the point we made earlier on, which is to the effect that at the time of the grant of the interim order, there ought to be reasonable, natural facts to convince the court, even though it is interim. It is at that time, the case of somebody's property being adjacent to a suspect's own, and then you get an order to attach all of them, and the judge, simply on the strength of somebody being investigated or somebody being suspected, grants such order. That question underscores what you are talking about, and that is all the more reason why the Superior Court should review the case of, starting from, like I said in my paper, the cases of all the cases I cited when I was reviewing this paper, from Dangaba down to AL Securities Solutions Limited against EFCC and Dan Patience Jonathan. This is another instance to justify the review of these cases by the Superior, particularly the Supreme Court, because if they do that, it now allows or enables the investigating authorities to do minimal work. Because the society where we are, reports or complaints to investigative authorities is not usually on altruistic reasons. Thank you.
Mr. Chairman, sir.
Yes, please.
I think that is all from us here. So if you can give your closing remarks, sir.
All right. Now, I think this has been the most explosive session since we started. All for good, and it's quite interesting and very thought-provoking. So I thank, with all seriousness, all the presenters, D.C. Nwelu, Michael Zekome, the representative of Senator Matthew Roide, who was ably represented by Nedai Masro, Senior Legislative Aide to the distinguished senator. Chief Governor Blah, represented by Mr. Biti, and Rajo Shitu. This is an unforgettable session, and I thank you all for the industry, for the delivery, and for the candor. I think that these are your footprints in the sands of history will not be readily erased. I like to just add that your papers are going to go into further publication apart from the material, mimeograph material we have, of which you'll be given a copy each if you have not already been given a copy, and a complimentary copy of volume 4 of the Legal Practitioners Disciplinary Committee reports. So if you have any updates or any adjustments that you want to make to your final material, please, within the next 30 days, kindly do so. Because then the communique will be ready and we will then cause to be published the proceedings of this conference and then distribute to the stakeholders. The Honorable Attorney General of the Federation himself involved, the Law Review Commission, which I don't know why they are not here, and other key stakeholders in the criminal justice system. And also we'll make them available at a subsidized price to law students, law teachers, and junior lawyers so that they may begin to have a feel of what is required in criminal litigation and what is required for us to have a sane society operating under the rule of law. So I thank you very much. We hope that God sparing our lives next year, we call on you that you would answer our call. And as we continue to improve the quality of the discourse, we hope and pray that those in control of the executive arm of the government will continue to improve and refine our criminal justice system. Because at the end of the day, that is what defines our society. Whether investors will bring in their hard-earned money to put in the society depends on the kind of justice delivery system that we have. If we have a porous, scratch the surface only justice delivery system, I'm sure that it will not take us too long to find out that we are going to be an economically dependent nation. So I thank you very much. I hand back to the moderator for some housekeeping announcements and to prepare for the afternoon session, which is also an equally thought-provoking session. So thank you very much, and I take my leave at this point.
Thank you very much, Mr. J. Let us give the panel a resounding round of applause. You can see the coordinator has already made my job easy. He has given more or less the vote of thanks and has appreciated each and every one of the panelists for this discussion. Just one question. Somebody has asked for Mr. Obla's paper because it's not in the brochure, and I want to assure the person that he will get a copy of the paper. So I want to thank everybody. This is the end of the first session. We'll continue the next session, which is the session on cybercrime. Cybercrime and the issue of confiscated assets. A lot of issues have arisen in the aspect of cybercrime, the hush puppy and the rest. So that will be another engaging session. Please, by 1:15 we'll resume for that session. Lunch is served, and we'll have a group picture with the panelists we'll have a group picture with all the panelists here, and your lunch, distinguished panelists, will be given to you in your pack as you're leaving. We'll make sure we put it in your car. So thank you very much, everybody, and have an enjoyable lunch session as you return back at 1:15. 1:15, return back. Thank you. Please, group photograph, please. Where are the photographers? Let us just have the group photograph. Just behind the... Is at home. Yes. Just here. Just take it.
Jumoke, have you taken your session today?
Yes. Okay, I should join them.
Agbiti, where is Agbiti? Let him join.
All the panelists, I think,
right? Bibi Daudu. Said Bibi Daudu. That's the one I'm taking. Right? Yeah, Bibi Daudu. Okay. Sir?
Okay, I'll be made to understand that our distinguished guests, they should go upstairs. There's a VIP section for the upstairs in Oga's office for you. Yes, please. So.
Hi, I'm Dr. Amy Killen. I have my own medical practice, and I've been